Buju, just making sure that all of our folks are have their cameras on, and so then we'll get started in just a second. Okay, I think that we are ready here. Buju, everyone. My name is Laura Newton, and I am the Indian Child Welfare Program Director at the Minneapolis American Indian Center. And I'm just happy to be here today with all of you. We did provide this presentation, and actually, this presentation is geared mainly to our work as part of our collective work group, which is the Metro Urban Indian Directors in Minneapolis area, um, which is made up of tribal ICWA professionals, um, county agencies, social workers, county attorneys, public defenders, Indian child welfare, law center attorneys, and many different nonprofits that provide services for our American Indian families in the urban area as well as in the larger area of Minnesota. So without further ado, I'm just going to go ahead and introduce our panel, and I'll allow each of them to provide a little bit more information on themselves if they would like. Um, we'll start off with Mika Barrett, who is, I think, going to be speaking about her role previously as a worker for Red Lake. And I know that she also now is in an administrative capacity at Ramsey County. So welcome, Mika.
Bonjour. Wemiko Sindishana Kaz Makwan and Dudame, St. Paul and Dunjaba. Miss Kwagami Zaga Iganing Ishanakada Ishkonagon Winjabayan. Hi everyone, my English name is Mika Barrett. Born and raised on the east side of St. Paul. My family comes from the Red Lake Nation. I'm just really grateful to be here today. Miigwech.
And we'll go next to Ben Lundquist from the Mille Lacs Band. Oh, sorry, we are not hearing you.
Good morning, everyone. My name is Ben Lundquist. I'm a Deputy Solicitor General with the Mille Lacs Band of Ojibwe, and I just want to say what a real privilege it is to be here with you all this morning. Thank you.
Next, Michaela Maxwell.
Hello, I'm Michaela Maxwell. I'm a tribal liaison, one of three at the Minneapolis American Indian Center that Laura oversees. I am an enrolled member of Red Lake, but I'm also Ihongtawan from South Dakota, and I'm Santo Domingo Coche de Pueblo from New Mexico.
Great. I think that we also have with us today Sadie Hart, who is one of our co-chairs of the Metro Urban Indian Directors, and I believe Nina Vongpeth, who is also one of our co-chairs from the Metro Urban Indian Directors. If either of you wanted to say hello, you certainly can. I can't see everyone's camera. So if I don't see someone on screen, we are expecting possibly one other person to join us, Shayna. So if someone does see her from my team, if you would just kind of alert me that she is now here, but I don't see her at this point.
I am
So I
here.
think we'll go ahead. I'm sorry. Did someone have? Oh, I thought I
Hello,
heard.
can you hear me?
Is this Shayna?
Yes, it is.
Oh, great, great, Shayna. So you're on the phone, correct?
Yes, yeah, I'm on the
Oh,
phone because my
okay, great.
it's not like, but I'm here.
Okay. If you do want to just introduce yourself briefly.
Oh, okay. Um, my name's Shana, and I am from the Red Lake Band of Chippewa Indians. I am here to share my experience with you guys. Having a ICWA case.
Okay, wonderful. We thank you so much, Shayna, for coming on with us. I will definitely call on you when we get to that point in our agenda. And I was wondering, I'm not sure who is running the teams right now, but I'm wondering if there's any way to turn off the who is being admitted. It's just a little distracting, but or if there's a way that I can do something with that.
I will find out.
Okay, if not, no big deal. I just thought it might be easier because I keep thinking that it's someone else coming up for my team. So,
Yeah, I will
anyways,
find out.
thank you so much. So, as I was saying before, our presentation typically is geared towards talking about the tribal role in child protection. And the reason we came up with this presentation is so we could inform and work with our families to help them better understand, exactly what their tribal Indian child welfare social worker or liaison or the attorney for the tribe, depending on who it is that might be present at their case. But what really is the role of that person in the case? What types of things do they do? What can they help with? And really kind of like what some of the differences might be between different tribes and what is relevant based on the Indian child welfare law. So with that disclaimer being said, I know there's lots of folks here that have lots of knowledge about Indian child welfare. So just keep that in mind that our presentation is really for you to kind of see how we present this material to families. This is recorded and we do have it on YouTube. And so it's something that we can share with the group here afterwards by email, the link, so that you could also share it with families, the presentation that we had done previously. Um, the first thing I want to talk about and kind of talk about with our panel is to turn it over actually to Mika and to talk a little bit about what you see as the tribal involvement in court. When do tribes become involved? Um, and also, what active efforts can tribes, I guess, can you talk about regarding family reunification? How do the tribes, how are they proactive? How can they be proactive? And how should a county work with the tribes before court involvement? So in Minnesota, that would be before the Minnesota Indian Family Preservation Act notices or at that time. So I'm going to turn it over to you, Mika.
Great, Miigwech, Laura. So again, my name is Mika. I currently have a supervisor position within Ramsey County, a county here in St. Paul, with their Indian Child Welfare Unit. I just came here in November of 2021, so I'm fairly new, even though it's hard to believe it's almost been a year. I supervise both intake and case management currently. My previous work was with the Red Lake Nation as an ICWA social worker. So we, serviced all child protection cases that were off reservation across the state and country. So I think a lot of my talk today will probably be more so geared about what we're trying to change here within the county, so I can have my respective tribal leaders and partners talk about their perspectives as well. Um, but for the county, we're obviously trying to involve the tribes as soon as possible. So once that call comes in to child protection, our screeners are trained to ask about heritage. And it is the role of the intake worker to notify that tribe within 24 hours of that intake call. So where it's a it's an obligation that we have to do for our tribes and our tribal nations and our partners, right? And so that's what I'm training my staff to do is we need obviously under ICWA and MIFPA, but we are trying to involve the tribes from the minute that we get that phone call into child protection. And we have 24 hours to do so. So here in Ramsey County, we have an active efforts specialist. She is the one who essentially makes the notices for our agency and sends them out. So she already has a collaborative relationship with the tribes here in Minnesota as well as across the country. So she's kind of our one-stop shop when it comes to those notices. And when it comes for active efforts for family reunification within our counties, we are trying to involve tribes, again, like I said, right from the get-go. So once we know tribal affiliation, we're contacting them. We should be emailing them, trying to collaborate with them, understanding that we might not get a notice or like a determination right away, where we still have an obligation to keep our tribal partners informed. So a lot of times we would call up a tribe, they'll be like, well, it might, be a little bit till you get a notice. And so we're just still trying. So we ask, like, okay, what would be helpful for you guys? Would it be helpful for us to continue to phone call with updates? How would you like to be involved? Are email updates sufficient? And then we'll just kind of go from there. But we're always obligated to keep them updated and to involve the tribe as often as possible, especially when it comes to decision making. So I consider them a collaborative force. No decision is made without a tribal nation is what my motto is, especially working for the tribe at one point in my time. And yeah, so I don't know if any of my other panelists would like to chime in.
Yes, why don't we go to both Ben and then Michaela next? If you have anything else you'd like to add about those questions, kind of what is the role of tribal involvement at that point from the beginning get-go of the case? And then how can the tribe be proactive, and how can the county work with the tribe prior to court involvement in providing active efforts?
Well, I would just say, I mean, a big part of it would be exactly the things that Mika is describing, uh, reaching out to the tribe and looking at the tribe's um, opinion and voice and getting them involved right off the bat is wonderful, and we really value that. A lot of tribes don't have a big deep bench of social workers, and so there's not always going to be somebody that's assigned from the tribe. But at minimum, what tribes want to do is at least if they're not actively out in the field on this case, keep themselves abreast of what's going on and make their voice heard if they have an opinion, if they think the county needs to be doing something differently, if they're unsatisfied with the direction that it's going. And if you don't have someone like Mika or her team that are proactively reaching out to the tribe, I think the tribe needs to be raising their hand and trying to get in there and be heard on these things. You can have an attorney attend the hearings, even if you can't assign a social worker. And there's different ways for you to be involved in these cases and make the tribe's position known, even if you don't have, again, a big social work bench or a big department that's assigned to these cases.
Great, thank you, Ben. Why don't we go to Michaela? Do you have anything you would like to add?
Yeah, just from my perspective, since I am a tribal liaison, I'm not an attorney, or some tribes will have their own social workers, like Mr. Lundquist just stated. So my role is just like the eyes and ears, so like the go-between between the county and the tribe, the tribal rep or the ICWA specialist over there. And a lot of times, a lot of the tribes in South Dakota that I work with don't have the manpower basically to cover all 50 states. So I just help them wherever I can. And yeah, it's just helpful.
Great. One of the things I would just like to add too, because we have so many folks here from all over, and I recognize lots of names, so it's nice to see some of our tribal partners that we have worked with in the past at the Indian Center. And so I just wanted to state that the Minneapolis American Indian Center does provide services for tribes outside the state of Minnesota free of charge. And so that is what Michaela does in her role as a tribal liaison, is, as she said, serve as an eyes and ears and a connecting point between the tribe and the county. She can attend meetings just like just like a tribal worker would do. So she really is the person on the ground here in Minneapolis for several different tribes, along with her counterparts. Our next question is about what is actually about why is my tribe not involved in my case? So this is something we hear a lot from families. And So I'm going to once again go to all the panel members. We could start with Ben in this case, and then maybe go to Michaela and then Mika. So why is my tribe not involved in my case? One of the things we can talk about is that tribes in different states use different definitions of how they determine their membership. We always let parents know that it is up to the tribe. We and reinstate this with county and state professionals that it's it's the tribe's role to determine their membership, and solely their role. So sometimes folks get that confused and think that all tribes are the same, or so that's something we really try to reiterate. So I'm just going to hand it over to you, Ben, if you have anything you'd like to state, just from your perspective, and then we'll go to Mika after, or I'm sorry, to Michaela after you.
Sure, Laura. So just to dovetail off your comments about tribal membership, so it is up to each tribe who is a member at the Mille Lacs Band for purposes of ICWA cases in state district courts. We regard, first of all, people who are in fact enrolled, and then for purposes of ICWA, we also include people who are maybe not enrolled, may or may not be eligible for enrollment, but they're a first descendant or their parents are enrolled, and that's how we do it. And those are the cases where we get involved. And every tribe, again, has their own criteria. So perhaps the issue is that your tribe's not involved because they, maybe you're a first descendant and your tribe doesn't, they only show up when it's an enrolled tribal member. The other thing, again, I think is just kind of the resources and the organization structure. This is just kind of speculation, but if you're part of a tribe that's smaller and just doesn't have the governmental resources, they may not have somebody that's able to review the different ICWA notices as they come in. Or if they are able to review them and see that there's a case, they might not feel that they're in a position to have a social worker, have an attorney show up. And if they don't do a lot of that, they might not be aware of all the different avenues that the tribe has to be able to make its voice heard and its recommendations heard without necessarily attending every court hearing. So those would be my thoughts on that, and I'll pass the baton now.
Okay, Michaela.
Hello, yeah, just going off of what Mr. Lundquist just stated, a lot of the tribes that I work with don't have the manpower to assist in being involved, but that's why my role is there to help them. But it does depend also on enrollment qualifications, just like Mr. Lundquist just stated. Some of the tribes you might have to be like 1/4, or just depends on every tribe.
Mika.
Thank you. So I can talk about my time at Red Lake. So when I first came, when I went to the Red Lake Nation, I think it was, the spring of 2018 after I graduated from my master's program, and there was only 2 of us working for the tribe. In that specific instance, we were only working with cases that were involved in court. But then we started, we had the opportunity to game plan, really try to structure our program with Red Lake ICWA, advocate for our needs and our wants. And it took some time, but we eventually got to grow our team. So by the time I left in the end of October, we had a team of about, 6 to 8 workers who were working specifically within ICWA. So we had case managers, we had prevention workers, we were doing our own ICWA MIFPA notices, but thankfully that was due to the trust and the resources available to the Red Lake Nation and their residents off reservation. So I've always been super grateful for that. And the team continues to grow, I believe. So that's just super exciting. But when it comes to membership, each tribe has their own requirements. So Red Lake is separate from like the Minnesota Chippewa tribe. So we have the ability to change our blood quantum requirements at the Rural Tribal Council. So during my time, we had some elders in the community go to tribal council and ask for descendancy changes within Indian child welfare, because elders in our community and parents are experiencing that their children are no longer eligible under the Indian Child Welfare Act because of our blood quantum requirements. So tribal council heard that out, and we had the ability to work with relatives whose parents were enrolled, but those children were no longer, or who were not eligible for enrollment. So that was a huge shift in our ICWA work. We saw a big influx in cases, and we got the ability to sit at the tables with our descendants and our children. So that was a big win for us and our within our Red Lake ICWA team. We got to work with families who were considered non-ICWA, you know, a month prior. So that was exciting. And then Red Lake also, I want to say, like, I'm going to get my years mixed up. The last few years have been a blur, it feels like. But we also, Red Lake Nation also changed their enrollment criteria, which has been really amazing. So I just like to give this example. My dad's a citizen of the Red Lake Nation. Prior to this change, me and my children were not eligible for enrollment because we did not meet that 25% blood quantum requirement. But after the passing of this, both me and my children got to be enrolled. And then the cycle begins again, right? So my children are now 25%, meaning my grandchildren probably won't be eligible unless, you know, there's a Red Laker involved. But it just shows that we're changing as time evolves. We're seeing the effects of blood quantum. Another form of genocide is what people like to call it. And we're doing what's best for our people and changing those requirements. My hope and dream, I guess, is to see descendancy with the Red Lake Nation, but I know that's probably a dream of mine that won't occur anytime soon, but we're moving in the right path moving forward. So again, I'm always super grateful for Red Lake and putting their members first when it comes to descendancy and the changing of enrollments. But with those resolutions, the Red Lake Nation got to be involved with cases much earlier and cases who were not considered ICWA prior. So those were exciting times when I was at the Red Lake Nation.
Great. Thank you so much, Mika, for bringing up Red Lake as the example. I know we talked about this in our previous training, and one thing that I just want to, I guess, point out to the group here, among all of my colleagues here that do work in Indian child welfare, I know that other tribes have done certain things to change enrollment or to recognize families for Indian child welfare purposes. We're going to have a point in time where we can take some questions. And so we'd love to hear from other tribal nations about, you know, kind of what you're doing. Certainly because this is such an issue with our families today. As we work in Indian child welfare, we just see more and more families that are not eligible for services, and it's a really hard thing to deal with and to help families to continue to get cultural services. Um, One of the things in our training that we talk about, and we'll talk about a little bit more here too, is just, you know, how to have the tribes be involved in case planning, and in how that might be impactful in making sure that there are culturally appropriate services for folks. So I'm just going to turn that question over to our panel to ask, you know, how have you seen tribes, either the tribe that you work for or other tribes, become involved in case planning, and you know, what have been some of those efforts? Um, can we start with you, Michaela? Is that all right?
Yeah, that's fine. Usually when it comes to case planning, the tribes, yes, do have a say in it, and a lot of the times it's like a basic, you know, like the basic outline of it. The tribes do have a say if they want to include or exclude things. That's it.
Okay. Ben?
So I think what I've seen is we've, you know, myself and the social worker that I represent in the case, I think that we have both advocated for the inclusion of certain items in the case plan, maybe more culturally appropriate programming in the case plan. And at the same time, we've also advocated for simplifying the case plan if there's things that look kind of redundant. I think the case plan is one of the areas where, when we're talking about the tribes having a say in the case, I think that's one of the more concrete places where you'll see that is in the case planning that goes on.
Mika, did you have anything else you would like to add regarding that?
Yeah, so just on the county aspect, on what I expect of my staff is to always involve the tribe when it comes to case planning, making sure that it's achievable and it comes from an unbiased view of the county of what we think is best. No, it does involves the tribe and the parents, right? The ones who are working on the case plan. So I always try to illustrate that the importance of involving not only the tribe but also the parent involved or the family supports, and understanding that everything on this case plan looks like a lot, but we can do it in steps. I'm not expecting everyone to do it all at once. That's going to be way too much work in the front end. And so, yeah, and then before we file case plans into court, we have to have signatures of like mom and dad, the guardian ad litem, my worker, myself, and I always have a line for tribes, ensuring that they get the copy of the case plan, they review it, they can edit it, they can give us suggestions, feedback, we can eliminate things, so on and so forth. So I believe that tribal involvement within those are key and very important to success of tribal members.
Okay, panelists, anything else you wanted to add? Okay, so typically we do have a few other panelists when we have done this training, so we're going through things a little faster than we normally would. I do want to offer Shayna, who is a parent who has had experience in the child welfare system. If you have any comments on any of the things we've talked about, if you have any suggestions for tribes and working with families or anything that you want to add, you certainly don't have to, but I just wanted to offer you space to do that. Okay, I'm not seeing that she's unmuting. So if you do think of something that you want to add, Shayna, you certainly can include that when you talk about your experience. Our next question that we talked about in our last training is in regards to active efforts and the QEW process. And really, what is that? So I know many folks on this call are going to know what qualified expert witness is, but I'm going to let our panelists explain it to you so that you can see how we explain it to families. So I'm going to have you go ahead and start, Ben, please.
Okay. So it seems like there's a lot of acronyms and abbreviations involved in equal cases, and one of them that you'll see or hear discussed quite a bit is the QEW process, or a QEW, and that stands for Qualified Expert Witness. A qualified expert witness is generally someone from the child's tribe that is recognized as an expert on tribal child rearing practices, on cultural standards, and they'll generally testify that the situation alleged to be going on in the child's home is not compatible with the cultural or social norms of the tribe. But just to give you a more exacting overview, it's 25 CFR section 23 discusses who may serve as a qualified expert witness. A qualified expert witness must be qualified to testify regarding whether the child's continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. A person may be designated by the Indian child's tribe as being the qualified expert witness. The court or any party can request the assistance of the child's tribe or the BIA office serving the Indian child's tribe in finding someone who's a qualified expert witness. Generally, the way it works is that tribes have people that they've designated as the qualified expert witness. Generally, the county will talk to the tribe and make sure that the tribe is on board with the removal from the home. and then ask the tribe if they would assist in coming up with a QEW affidavit. A lot of times what you'll see is the QEW or the qualified expert witness doesn't necessarily testify in a courtroom, but they will complete an affidavit. So what I'll do is if the county reaches out to me and the social worker for the tribe are in agreement with what's going on with the removal, I'll make arrangements to have our qualified expert witness come into the office and just look over the file and look over a draft of the affidavit. And I'll make myself available if they want to talk about it or have questions. And if we agree that out-of-home placement is justified, then we'll help supply the affidavit. And just to be clear, if a state district court is going to remove a child from the home, put them in foster care, or try to terminate parental rights, you always have to have a QEW that is on board with that and says that they're on board with that. I discussed a little bit earlier the qualifications that QEWs typically have, but really, once the tribe designates somebody as a qualified expert witness on behalf of the tribe, their qualifications aren't subject to challenge. The QEW's position can be challenged on cross-examination, but their expertise itself cannot be. Just to clarify a little bit more about when the QEW's testimony or affidavit is needed. Again, it's needed when somebody is placed out of home. So it's in any kind of foster care placement or actions for termination of parental rights. Just as an aside, I know the tribe that I work for doesn't generally go along with any kind of termination of parental rights. And I think that's true more broadly of tribes. If you're not removing the child, say you just have a child that's subject to protective supervision, you're not going to necessarily need the QEW affidavit at that point. You don't need the QEW affidavit to remove the child in an emergency. You don't need the QEW affidavit at that first emergency hearing, but anything after that, you're going to require the QEW affidavit. I think I'm also slated to discuss active efforts. So Laura, I don't know if you want me to move on to active efforts or if we want to open it up about the QEW process first.
Maybe let's open up about the QEW process first, just to get a perspective from Michaela and Mika. Anything you have to say about QEW or what tribes that you have worked with or what the county has done in your experience regarding QEW.
Yes, in regards to QEW, just an example of one of the many ways you can obtain one is one year, my tribe from South Dakota designated an enrolled member from a California tribe to be a QEW, and then like a year or two later, they designated someone else within their own community as a QEW, and and the person that they designated like the previous year, the first year that I worked there, they had the county, it was the county's obligation to pay them.
Mika, did you want to add anything?
Yeah, sure. So during my time at the Red Lake Nation, I actually I had the privilege to be the qualified expert witness on behalf of the tribe involving ICWA cases. It humbled me essentially when I came, because I never thought that I was qualified, but a lot of consultation, with my partners, with my my attorney on the homelands, with my boss, I grew comfortable with the position. And so I started to figure out a way to be effective QEW. So I took it upon myself to know every single case that came into Indian Child Welfare Unit at the Red Lake Nation. I had regular consultations with folks, and we had on Monday mornings, we had staff meetings, and we would talk about the qualified expert witness affidavits that were needed at that time. And we would talk it over as a team, and ultimately I would decide if I'm ready to sign it or not, or if there's more efforts that the county could bring in prior to submitting my affidavit or testimony. so for most of my practice, I just signed an affidavit supporting, you know, the placement of these children. I've also had some cases where I simply did not agree, and asked for the child to be returned back under certain circumstances. And a lot of times, you know, counties were okay with that. They're like, okay, yeah, we'll change our practice. We'll bring this child home. And other times I've had to go head to head with the county on trials. And I sat in on a trial one time, where the county was really adamant about removing a child. I said, no, like we need to bring this child back home. They ended up trying to hire their own QEW. And so we had a QEW battle, I like to say. So and essentially the court sided with me because I was the designated tribal QEW on behalf of the family involved. But those are just some of the things that occurred as a QEW. And also, if I felt that a child should be returned home after signing a QEW, say 3 months ago, where I supported the removal, I can come back and revoke my QEW, and I can send in a statement stating, or a new affidavit saying, this is what I support right now. We support bringing the child back home. And these are the circumstances as to why. So the QEW holds essentially a lot of power. I'm air quoting that. I don't really like using that term, but it's a serious role, and yeah, I think that's all I have. Sorry, I lost my train of thought. But it was a humbling role for sure.
One that I asked you to do.
Thank you so much, Mika.
But there's supposed to be a section where it says referrals
Must have a
and where you make referrals to, and that's not popping up.
somewhere.
On a tracking form.
Okay, Ben, if you wanted to continue, there was a question here. I'm just trying to figure out where that was back in the chat here. The question was, when you say the expertise of the QEW cannot be challenged, does this mean other areas of the QEW can be challenged? So that, I think, was directed towards you, so I'll let you answer that.
Sure. So I guess what I was trying to say is, in other types of civil litigation, you can basically attack somebody's credentials and poke holes in the very notion that they are, in fact, an expert. You can't do, when it's the tribe that puts up a QEW, their expertise, their qualifications to testify can't really be challenged. But the things that they are saying or recommending, I think, can be, you can kind of try to poke holes in what their opinion is. So you can't challenge the fact that they're an expert and that they're qualified to give testimony, but you can ask them questions under cross-examination that maybe erodes the potency of their opinion. You know, you might ask them, well, have you met this family? Well, how much time have you spent with this family? So you haven't met the family, so you have no firsthand. And I don't know how useful that typically is going to be. But I hope that makes a little bit more sense, that you can't challenge their capacity to be the witness, but you can challenge the things that they are saying or recommending as the expert witness.
One thing I wanted to add too, because I have had experience both as a tribal rep and as a tribal liaison at the Indian Center. You know, one thing that was talked about here is that's really unique to Minnesota, I think, more so. It's not always practiced in other parts of the country, is this affidavit practice. That really, I think, kind of stemmed through Hennepin County, which is our large metro county in the Minneapolis region. And so I'm just curious, Ben, if you have, does Mille Lacs QEWs, do they sign affidavits, or do they only provide, oral testimony? I know each tribe does it differently, and I'm not sure.
Our QEW provides typically just affidavit testimony. I think a lot of these cases don't go to trial. If we have a case that goes to trial, we would make the QEW available in person for the trial. But just as far as admit deny hearings and pre-trial recommendations, we always use the affidavit process. And I just think it stems from, if you have a case in Ramsey County you know, are you going to make somebody drive down from Mille Lacs to St. Paul just for a admit deny hearing and what the recommendations are there. So to answer your question, I'm sorry. Yes, we typically just do the affidavit, but if we were to go to trial and people were calling witnesses, we'd make the QEW available for live testimony for that.
Great. We do have a comment here from Liz Lovejoy just saying that they've seen QEWs challenged by county attorney. And I'm not sure where Liz is from, just from what I'm reading, but and I know we'll have some more time for questions, but so we might have, just to put that in our panelists' mind, to maybe talk a little bit more about that later. Omaha tribe. Okay, so Nebraska. Or it could be challenged anywhere in the country, probably. In Minnesota, I know we have a tribal state agreement. And one of the things addressed with that and with MIFPA kind of talks a little bit about challenging QEWs and the right for, the tribe to identify their QEWs. And I know just in the length of time that I've been practicing that came about because of the numerous challenges that happened in the probably late 80s and early 90s. And so I don't know if, I think it really still depends. I'm sure we still see that different places. But hopefully, I don't know, Mika, if you want to state anything, but I think that there's policy in some of our metro urban counties to not do that, but I don't want to speak for the county, so.
Yeah, I think for the metro area, we are not subject to that. But I know in my experience, I probably had a handful of times where my expertise was challenged. I think of specifically when we have cases out of state, they won't accept an affidavit. Instead, they want me to present why I'm qualified. So they have like a series of questions like, who are you? What's your name? What's your affiliation? How many years of practice have you had? What makes you qualified for this role? And it always felt really icky to me to answer those things, especially as an Anishinaabe and Indigenous woman, right? Like, what makes me qualified on behalf of these children, right? And families. But yeah, so they would just ask you a series of questions, sometimes lasting like 30 minutes, the questions. And it's just basically for the judge to listen. And I mean, they're almost always gonna say you're an expert. I mean, who are they to not say that? But it's an interesting experience, honestly. Because then for me at the time, I'm like questioning, well, am I even qualified? And yeah, I think I've only had that a handful of times. I've had it here in Minnesota with my QEW battle in one county. But for that family specifically, I knew the family. I've worked with the family previously. They are citizens of our nation. And I knew the case, and the other QEW didn't. They're just going to be paid by the county essentially, and we're given a case file. So that was kind of my lead in that QEW battle, the fact that I actually knew that family. But it happens. It's an uncomfy situation for sure.
Anything else from our panel regarding that? Otherwise, you can go ahead and talk a little bit more about active efforts.
Okay. So active efforts is also a term that you're going to hear quite a lot in the context of ICWA cases. This term, it comes out of the ICWA statute itself. I think 25 USCA section 1912 states that any party seeking to effect a foster care placement or termination of parental rights to an Indian child under state law shall satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that those efforts have been unsuccessful. So I think can be debate back and forth about what exactly active efforts look like and what's good enough to meet that bar. What I would tell you is that they're distinct and a step beyond reasonable efforts, which I believe is the standard that's typically required in a non-ICWA case. Just a little bit about what it is or what it isn't. There's a court case from Montana that held that under ICWA, the term active efforts by definition implies heightened responsibility compared to passive efforts. To me, it's an extra layer of efforts where you maybe walk the parent through the case plan step by step, rather than just, giving them the case plan and leaving them to their own devices to accomplish it. Just a couple of examples that I can think of. Reasonable efforts might just be making somebody a referral to a drug treatment facility. But, if you're in an ICWA case and you're required to go up a step to active efforts might be that that you drive the person there and get them there. Another example, and this actually comes from a Minnesota Department of Human Services presentation. Reasonable efforts might be, helping somebody who needs housing by just giving them, a pamphlet with information about local resources, whereas active efforts would involve, helping the parent go through the housing process, helping them with paperwork, helping them contact agencies, driving them to meetings with prospective landlords, et cetera, et cetera. So that would be, I guess I would maybe defer to some of to Mika or some of the others for maybe more examples of just what active efforts are, but they're just that heightened level of effort to prevent the removal or to facilitate the reunification where there has been the removal of a child.
Yeah, so a practice that we're trying to implement more at Ramsey County since I've come in is prevention work. And so we're trying to put all of our resources and education within our intake unit. So I currently have, when I started, I had one intake worker. We currently have two, and we have the ability to hire a third one now. So I'm hoping to continue to see that unit grow and continue to advocate for the more need of intake workers, especially who are familiar with Native American culture and customs and the way we raise our families, right? And it comes from an unbiased approach. So what I'm really trying to do is to keep a lot of our cases within that intake investigations unit. So we can stay open for 45 days, but we can stay open longer, and really finding alternative ways of not bringing this family into case management unless needed, or to not bring them into court. So a lot of my standard questions are, what efforts have you done? When cases are coming to me about next steps, I'm like, did we talk about ADOPA? Did we talk about a voluntary placement agreement? How have we been reaching out to family members? Do we have a family arrangement that we can do in the meantime? So really just starting from the forefront and building from there to try to prevent cases from coming in. And since my time, we've only had a handful of cases come into case management. But we are closing so many right from the beginning, or based off screening guidelines, maybe a baby born with THC, right? Those have to be screened in. We go in, we assess, we safety plan, and we send this family off to be successful. That's nothing that we need to bring it into court for, usually, right? We also are providing a number of, we call them CADs. I have no idea what that means, CADS, but that's kind of our money generating system within Ramsey County. So we're providing families with gift cards. I'm like, give these families Target gift cards, Cub gift cards, gas gift cards, because it's, as much as they don't want us involved, we don't want to be involved either. But we're here to assess safety and bring them something like, hey, I'm sorry that this is occurring, that we have a child protection report, but here are some things for you. So I always try to make sure that our families are getting gift cards of some sort. We're also provide phones and phone minutes, bus cards. Those are just kind of the active efforts that we do right on the forefront. And just involving families. So really using the Signs of Safety model. I'm not sure if anyone is really familiar with that. But involving the family in the entire case from the beginning to the end, using their voice, using family supports, and not making decisions in isolation as the county, right? So involving our tribal partners, our community partners. We have a huge amount of resources here in St. Paul, Minneapolis that are Native-run agencies, elders and residents, parent mentors. So really trying to provide families with resources right from the get-go, so we don't have to see them within child protection or case management services. So those are some of the things that we do.
We didn't hear you, Laura.
Oh, Michaela, do you have anything you'd like to add? I seem to have lost her feed. So hope, oh no, I do see her. So she must have had to go off camera for a moment. Some people have been freezing up here and there too. So one thing I might just add in my practice, and something that I always encourage our tribal liaisons to do, is to to talk to their families about you know having their tribal worker attend meetings with them, or at the Indian Center, we have some advocates, some of our other urban agencies, or in other parts of the country, there are different, advocates that can attend and be part of the planning. And that's one thing that we always ask for, is to just have the tribe included in whatever they are able to be, present for. That teamwork is, and continually doing that, reaching out as a county professional, is an active effort. And by doing that, it just creates a much more collaborative environment. Um, the other thing that I think that is really helpful is anytime that workers are actively bringing, bringing their clients to appointments, and not just giving them a bus card, but actually bringing them, explaining what is happening. Or if they can't explain something, then making sure that their client has the resources to be able to understand. That's a very important active effort, and one of the reasons why we do these trainings for families, because, in our practice, I think all of us in our Metro Urban Indian Directors Family Preservation Group, have heard from families that we just don't understand what's happening in our cases so much of the time. And we all get so much training as professionals working in child welfare, um, because ICWA is confusing. It takes some time to get to learn. And so our families need that same information. And so that's one of the things that we try to do. It looks like we have a question. Selena, if you would like to unmute, you can ask your question.
Yes, I have a question. We had to do some proposals this year with the state, and I was a little confused when they were talking about preservation, family preservation, and I was thinking, what I understand that keeping the families together, reunifying, but I don't think a lot of time the state really understands the preservation, because according to them, it's open cases. And I noticed that before I came on, a lot of folks were getting assistance from the state. But when I, had to redo the proposal, I was advised it had to be open cases. And I was trying to understand the fine line between preservation. So I was wondering if you could explain that a little bit.
Well, I could start in that. So I think we've talked about it in a couple of different ways. So I think that we might have been a little bit confusing as well. So, there is family preservation as far as, trying to have active efforts and do everything possible to prevent removal of a child. Uh, we, as part of our Metro Urban Indian Directors, we have a family preservation committee, meaning our group is really geared towards early intervention, trying to do whatever we can as professionals to keep families together. That could mean prior to a removal taking place, but it could also mean keeping children with family members and doing whatever is necessary to um, retain those family placements. So, if a grandparent is able to take children into their care and custody, that might be helping to remove some of the barriers for them to have, additional children in their home, whether that's financial or space wise, or with maybe them needing, additional help for a child with special needs, all of those kinds of things. So I'll turn it over to the rest of the panel for your comments. Go ahead, Ben.
Yeah, I guess preservation, as I understand it, it can refer to one, keeping the family together prior to any kind of removal, or two, like Laura was saying, it can involve a situation where there's been a removal, but how can we A, reunify with parents, or B, keep the child with some other component of the family and keep the broader family together. So if you're talking about preservation in the context of where there's court involvement and a child's already been removed, I suppose in that context you're talking about preservation through the reunification prism, more likely.
Yeah, and so like within our county area, when I say preservation, it's essentially avoiding removal at the court level, essentially, not having court involvement. So that could include a family arrangement that the family makes up and makes sense for them. And that could be a biological family member, that could be a family friend, and we're safety planning in that around that, assessing safety, providing resources. I also, my intake workers, they're applying for foot vouchers with families. They're applying, so like the housing, they're maybe we have to do childcare assistance, maybe MFIP. So we're referring families with what they need at the forefront rather than waiting for a massive disruption to occur and having it come into court. So really taking advantage of those first 45 days with an intake and investigation and really assessing family needs and wants in order for them to be successful outside of the child protection system. And so also Ramsey County has a few family preservation like groups that they have. So there's PSOP, so Parent Support Outreach Program, which is a voluntary program for families to be involved in. So it's outside of case management and court involvement. And there's also Mothers First, which is another prevention program that is completely voluntary for families. So a lot of times my intake staff, we set up resources for families, we get them in a good place, set them up with some financial assistance or whatever, then we will ship them off to either Mothers First or PSOP for additional supports if we don't see that court involvement is needed for that family.
Okay. Hopefully we answered your question. I know that can be confusing from a tribal perspective with different grants, because I think, yeah, I think that there can be a couple of different ways where family preservation can be defined. Our next question, or really kind of one of our last questions here, is what happens when a case goes non-ICWA? So by saying that, meaning when a case, a tribe that is involved in a case, or all the tribes involved in a case, identify that this case, that they would not, intervene, or that they would not consider this to be a child that is eligible for enrollment, and that, then perhaps the court then makes a designation that this is no longer an ICWA case. So I'm going to turn that question over to our panel, whoever would like to start first.
I choose Ben.
Okay. Well, I was gonna choose Mika, because the way I understand it, and this may vary from county to county, state to state, but I think at the county level, or in Ramsey County, as I understand it, we might stay with it as though it's an ICWA case, even without necessarily the evidence of enrollment and that kind of thing. So you might have a case that stays ICWA, or being treated as though it's ICWA, even if it might not be eligible. Am I close?
Yeah, so say we have an out-of-state tribe that we're trying to find eligibility for. We are obligated to keep that case ICWA until told otherwise. So we have a few cases right now that we're still trying to determine enrollment or eligibility of a family with a tribal nation, and it's been maybe a few years. And we continue to send notice every so often. But we have an obligation to continue to do active efforts for that family until we are told otherwise by that tribal nation. So no judge can deem it non-ICWA without tribal involvement, saying that they're not going to intervene on a case. And we have some cases that go non-ICWA within our ICWA unit that's already assigned to an ICWA worker. Understanding the nature of blood quantum and the original agenda for blood quantum, right, by the federal government, a lot of times we try to keep those non-ICWA cases within our ICWA unit if we have the capacity, because at the end of the day, they're still a Native family. And we're going to still provide active efforts for that family, even though the court doesn't see it as ICWA. But we're still going to, continue to support the family, provide active efforts, even though we're not obligated to do so. It's just our practice and model. And in the near future, there's talk about Ramsey County moving towards the active effort model rather than reasonable efforts as an agency-wide thing. Our agency really values active efforts and how it's the gold standard, right, of working with families. So I hope to see that in the near future. But yes, we are obligated to work ICWA until a tribe tells us otherwise. And if we have capacity, we try to keep those cases within our unit.
The other thing that jumps into my mind is that even if you're in a situation where a case goes non-ICWA, there are quite a few nonprofits, at least in the Twin Cities, that are there for Native American families. And even if your court case has gone non-ICWA, I'm thinking a lot of these nonprofits are still gonna be there for you. They're not insisting on seeing that you're enrolled just as long as you identify as Native American, and they're going to be able to help give you some supports as well, and maybe help fill that vacuum a little bit. Maybe they can help get you to a Rule 25 assessment, or provide transportation, or help you with some of these things too.
Michaela, do you have anything else to add about like cases becoming non-ICWA or just about this process? Because I know that you work with tribes all over the country, and some of the tribes that we work with, sometimes with their blood quantum requirements, they may not intervene if a parent isn't enrolled. So if you could talk about that at all.
Yeah, so when it comes to the case potentially going down to ICWA, a lot of the times, for the reason being, like Laura just stated, they want to have a parent enrolled. And sometimes if we're quick enough, we could help get the parent enrolled or their application in. And then hopefully, that'll make their child eligible for enrollment or descendancy in some of my tribes. A lot of the times, some of the tribes will still like to have it like monitored if they have like the resources for those non-ICWA cases, just to like keep, like, things can change, with blood quantum and like policies and council and stuff like that. But that's it.
Okay. And then we do have a question here. I think it's directed at you, Mika. Are you able to see the chat?
Yeah, I'm curious if you can give more context on that, Valerie.
I'm just wondering, we get notifications, Ho-Chunk Nation gets notifications a lot of time from You're with Ramsey County, correct, Mika? So if we are getting a notification, because in some situations, if we can still do like the monitoring for those first gens and offer those resources and services, we'd sure be willing to have discussion about that. So I'm just wondering if we need to look at how we respond to Ramsey County a little differently with those first gen folks.
Yeah, so I think when it comes to notices, like we're sending you guys notices, right? And if they are eligible, we would ask for a reply back. And I think our main contact is Christy Seinert. And so she, for DHS purposes, Department of Human Service purposes in Minnesota, we need that green card back, and then we need a notice, whether it's like a paper notice, I'm pretty sure is what we need to determine if it's an ICWA case or not. But even during that time, we would love to have consultations with our tribes if they're willing to do so. So like some of our tribal partners here in Minnesota, they won't consult with us at an intake level just because they don't have capacity to do so. They only specifically work on court cases, which makes it hard for us in a sense because we really want to collaborate. But I always tell my workers, okay, well, we'll at least continue to keep them updated, especially within tribal reviews. We're talking about these cases, getting some feedback. But I think however the Ho-Chunk Nation wants to be involved with their first gen, always reach out to us and our workers, specifically Christy, who's the contact on those ICWA MIFPA notices from Ramsey County. However we can get people and voices involved from the get-go, we are more than appreciative to do so. So it's all about collaboration with us.
Sounds good. And maybe we can just have some further discussion at some point. We can get a hold of you and talk about how we would do this for sure.
Definitely. I can put my info in the chat if that's helpful.
Thank you.
I was just going to add one of the things that at the Minneapolis American Indian Center we talk a lot about with some of the tribes we work with across the country is Minnesota is maybe somewhat unique in that, and Ben, correct me if I'm wrong, or Mika or Michaela, but I think because of our Minnesota state law, we do well, like as Mika was saying, the counties, can, and do sometimes, not all of them, follow ICWA cases, until stated otherwise. But also that tribes really can determine, the equal eligibility. So even if there is not tribal eligibility for memberships, we have several tribes in Minnesota that recognize cases as for purposes of ICWA. So there's a special designation that's in our Minnesota law, correct? Or is
I know that
the tribal state agreement? I always get that a little confused.
There may be something in Minnesota law, but I know that what we're basing it off of at Mille Lacs is that we, in our statutes, we basically deem someone an enrolled member of the tribe for purposes of ICWA if their parent is enrolled in the tribe. And I think there are other tribes that in Minnesota, like you say, that use that same formula where they, we want cases to go ICWA if it's the child of somebody that's enrolled, even if that child doesn't have the blood quantum for enrollment. And so we just kind of create this legal fiction that they're a band member, at least for the purposes of ICWA hearings or cases in Minnesota.
Right. Minnesota also doesn't require intervention by tribes on cases. You're automatically considered a party. At least that's how it should be. That's how the law states. So that's something that not all states have as well. And so that's something that, we wouldn't necessarily, we might be sharing this with parents, but we always let parents know that, your tribe can be involved at any point. If something changes with enrollment, we always talk to folks if a case becomes a non-ICWA case, like with families, we always say, if something changes or if we might even still work with them at the Indian Center in an advocacy role, because sometimes there are issues with, say a grandparent's documents or something. Maybe someone is not on a birth certificate that they thought should be, and there is a process that could be gone through to make that happen. Sometimes if a case is open long enough, something could change. So we always tell people to keep their tribe involved and to contact them if something, if they are able to get enrolled or something changes, because tribes should be able to intervene at any point. I've certainly worked with tribes that have intervened at the point of, like a parental right termination. where there's been a change in status. So
I
anything
think
else from our panel? Oh, I'm
Well, I
sorry.
think
Go ahead.
Nope, that's okay. With the county involvement too, is when a call comes in and maybe the reporter didn't know if the family had heritage, right? We look through our SSIS, which is a database system that we use, and if anywhere in there says the family has ICWA, or maybe the family at one time, maybe in 2016, said that they were from somewhere, and even if it was deemed non-ICWA at the time, we still have an obligation to send notice to that tribe, just because blood quantum could have changed, right, for that nation. So yeah, I remember getting those cases a lot when I was at Red Lake, because I processed all the ICWA MIFA notices from the state and country when I was at the Red Lake Nation, and a lot of times we had repeat families come in, and I know when I was processing notices, I'm like, oh, this family's not eligible, but I would relook in our system because, our blood quantum had changed since my time there. So, and then they would then become eligible. So yeah, that's just an example of what the county does. We're obligated to send those notices, even though our system says that they're not eligible or not enrolled, we still have to send those notices.
Does anyone, there's a question here. How much involvement does the tribe, or how much of involvement does the tribe have without overstepping boundaries? Anyone want to take that one?
I've never worried about overstepping any boundaries, I guess. I think the tribe is allowed to assert itself. And, if you see something going on that you don't agree with as a tribal entity, I think you need to speak up. You can supply a social worker that tries to work in tandem and in cooperation with the county social worker. You have your QEW, and if you don't agree with what's happening in the case, or you don't believe that there's justification for out of home placement, your QEW can say that. And again, the QEW can kind of almost work as a veto card on what the county is trying to do. So there's lots of things that the tribe can do, and I wouldn't worry about overstepping or anything like that, because it's the tribe's right to be engaged.
Yeah, I think during my time with the Red Lake Nation, we built it to be present and heard. So when I first started, it was really hard to get a word in. It was really hard to have an opinion, especially like maybe in northern or southern counties of the metro area, because there wasn't always a tribal rep involved in cases, just because we didn't have the man or woman power at the time. But we had to be consistent with families. We had to be consistent with what we were asking for, be present for families, and to build that relationship with counties. And a lot of times it was like sometimes talking at a wall, and it was like really hard to get your word in, really hard to get your perspective in, but to not give up, right? And to be a teacher in a sense when it comes to Indigenous values and worldviews, right? And how we expect to work with families and next steps, and just being present and available as much as you can, understanding tribal resources aren't as available compared to like counties. I very much value the voice of tribal nations and their involvement. And I think that's just that's also because, that's who I am as a person, but I also had that value and opportunity when working with the tribal nation and understanding how hard it is to work with counties sometimes. Sometimes they're really big bullies, but they don't know what's best for our families, the tribes do, and to really be stern and to really be intentional and collaborative and respectful in a sense too. Sometimes we have to be the bigger person, right, if we're being treated really badly by a county. But I learned that, my values as an Anishinaabe person really played a huge role when it came to advocacy for our tribal members and our families.
Anything else, Michaela? Did you have anything you wanted to add?
No, just I don't know if it really particularly relates to the question that they just said. It seems politics seem to be an issue within my own like tribe and experience. Sometimes it does hinder a lot the the progress of a lot of like cooperation or within the tribe to get things done faster. Politics in regards to like the tribal council and their ICWA department depends on like how they're set up. Just for an example, it may slow them down a little bit if they like cut some things or take away from something. But usually though, like that's where my liaison role comes in, and just to help them in whatever capacity I can.
Great. I think the last thing that we have here to discuss is about transfer of tribal cases. So I'm going to hand that to you, Ben, to just start, if you would, and
Sure.
And then the rest of the group here.
Okay. So under the Indian Child Welfare Act, if you have a case, if you're a parent or you're involved in a case that opens in state district court under the Indian Child Welfare Act, you can seek to have that case transferred to tribal court. In order for it to transfer to tribal court, you can't, both parents have to be in agreement. And either the parent of the Indian custodian can petition for transfer, or the Indian child's tribe, provided that such transfer shall be subject to declination by the tribal court of the tribe, is how the statute reads. So in other words, even if the parent or the tribe wants to transfer to tribal court, if the tribal court venue doesn't want to take the case, then it still won't transfer. Under ICWA, where there's a transfer from state court to tribal court, the tribe can request that the state judge direct that the entire child welfare and law enforcement file be sent to the tribal court. So there shouldn't be an issue with getting documents or evidence if it does transfer to tribal court. Because tribes are sovereign and they can make all their own rules, there can be different regulations on the tribal side as far as what needs to be done in order for the tribe to accept transfer. So some tribes might require someone to file something in tribal court first, requesting that the tribal court accept the transfer. Sometimes the tribal court might want to consult with the tribal attorney's office before it takes the case to make sure they have enough resources. So you're dealing with the state district court and going through the process outlined in ICWA to transfer to tribal court, but then you've also got to deal with the tribe side and any kind of regulations that the tribal court has, or different prerequisites that they have before accepting transfer. Why would you want to transfer from state court to tribal court? You might feel like you're not getting the services that you need, or the active efforts aren't being made in state district court. You might not feel like you're getting culturally appropriate services in tribal court. I've had the opportunity to work in some counties that do a pretty good job and have dedicated social workers for ICWA cases, but that's not the case in all of these counties. As I think we were kind of discussing, there are some counties where they just don't see a lot of ICWA and they don't necessarily understand what the obligations are. Just as far as kind of the differences between tribal court and state court. And I say this, I guess, with a grain of salt, because the only tribal court I practice in is Mille Lacs, but I think some of this is generally applicable. Tribal court is usually less formal, a little bit more conversational. I know our tribal court really values giving everybody the opportunity to have their say, and that may include different extended family members and that kind of thing. And there might be kind of talking back and forth that wouldn't necessarily be allowed in state district court. And I think the reason for that is I think our tribal court system that we have at Mille Lacs is in large part trying to not be the adversarial process that you might have in a state court setting, but instead trying to be a more consensus-based forum. Your tribal courts will also a lot of times not just be a system of laws and procedures, but also take into account certain tribal values. For example, well, right now our tribal courtroom is under renovation, but it previously had all of the Anishinaabe values printed on different sides of the courtroom. And so that was always supposed to be front of mind and a consideration. And that's not going to be the case in state district court. Because of tribal sovereignty, tribes can create their own laws on child protection and have their own rules. So because of this, there's kind of a misconception that the Indian Child Welfare Act applies in tribal court. It actually doesn't. Because of the tribal sovereignty, you can create your own child protection system and statutes. But I think what you'll generally find is a lot of the principles that are enshrined in ICWA, such as the placement preferences, the requirement of active efforts, you'll see that enshrined in tribal statutes as well. Another difference is you might have different timelines in tribal court versus in state court for determining permanency. For example, in Mille Lacs tribal court, we don't like to see cases stay open forever, but we don't have the permanency timelines, the rigid permanency timelines like you do in state district court. Tribes also might have different vehicles for achieving permanency. So in tribal court, a lot of times our cases end with guardianship and somebody who's a family member filing a petition for guardianship, whereas in state district court, usually it's the county that files some kind of transfer of custody petition. We have a similar mechanism to that now, but that's only just recent that we've developed that. So yeah, I hope that covers most of that subject area that you wanted me to address, but I'd invite anybody else to jump in too.
Other panelists, anything that you would like to state about tribal court versus state court or transferring?
I think during my time with the nation, we mainly saw cases go up to tribal court when there's been a disagreement on permanency. And the tribe has a pretty hard stance on what they would like. The state and county have a different stance, and there's kind of just no agreement whatsoever about that. So with the nation, we only had a handful come up to tribal court, and that involves consultation with your team, your supervisor, your tribal attorney, chief judge, to make sure that that transfer makes sense and is in the best interest of the family. Especially, let's say the family is located down here in Ramsey County, and then we're going to have up in Red Lake, let's say. That's a 5-hour difference, right? That's a 5-hour drive to get up north. So is that family going to be successful with tribal court? And essentially, we like to have a tribal worker outside of ICWA designated to that family. So is that going to be someone here in the cities doing courtesy case management on behalf of the tribe, or is it going to be someone up north? So all those communication and factors really come into play when it comes to families. And it's not a clear-cut process. It comes with a lot of thinking and a lot of planning. And essentially, at the end of the day, it's what's in the best interest of this family involved. So those decisions don't always come lightly. I know sometimes we had, I should say, families or parents petition to tribal court through their attorney in state court. And a lot of times the tribe denied those requests because that wasn't in collaboration with the tribe. So yeah, I've seen a lot of things when it comes to tribal court. We've had some cases come up due to the disagreement of permanency, and we moved them on up, and those kids got to be reunited with their family, where the state court was trying to deny that. So yeah, that's kind of been my experience.
Okay, I think Michaela had to go off camera for a moment. I would just, I guess, like to add, just because I know we have a pretty diverse group from various places, that both Mille Lacs and Red Lake are considered in the state of Minnesota to be 4E initiative tribes, meaning that they receive 4E funding direct for family services and foster care. I know that that's something that does have a great impact. I mean, I'm sure that you, Mika, got to see during your time at Red Lake and just the expansion that was able to happen. I know, Michaela, you have experience with some of our tribes, in South Dakota or in Montana, that maybe have one tribal worker for for the whole country. Do you have anything else you want to add, or?
Yeah, so they'll have one worker sometimes to attend hearings all across 50 states and to do the eligibility checks. And that can be really difficult for, for courts because they have a timeline, and also like culturally different. NATOs don't really have a timeline versus, courts do. And when it comes to transfers too, because of the so little like funding and the help, some of my tribes don't really transfer to tribal court because they can't afford it, and to help their people as they wish they could. In regards to, I don't know if you've seen that question, Laura, from Amanda, that what are some tips?
I did, but it just disappeared again, so I have to check it. But yes, if you want to answer anything.
Yeah, what are some tips to get tribes more involved and also to return emails or phone calls? I usually I would help them versus so I would be like the go-to person, because some of my tribes don't like the social worker or the mom's attorney to call them when they can just get all that information from me as a liaison. It's really hard to catch them, honestly. So it's just a lot of you gotta keep up on it, and it's difficult because I know you guys got your own work, your job descriptions, but that's just how it's. Yeah.
Anything else regarding that question about how to get tribes more involved? Anyone? I think one thing that I would add that when I've done trainings, for county workers and for other presentations, one thing that I always add is it's just important for counties to make relationships with the tribes in their state and in their area, as well as any tribes that they're working with, on child welfare cases. But especially, in the case where if a county is, right next to a reservation, certainly there should be efforts on the part of the county to do relationship building with the tribe, to have in-person meetings, to get to know who those staff are in those positions, to understand what their tribal structure is and their tribal government, and how many folks they have in the roles. That active effort on the part of the county is really helpful, I think, because it just creates, a better understanding of really what the capacity of the tribal workers are, as well as, just what many tribes that the Indian Center has worked with in the past. And I'm sure that some things might be similar with Mille Lacs or Red Lake. Some decisions are made for child welfare cases as part of a team. And so that's one thing we try to explain to parents sometimes, is sometimes there's a child welfare team, or there's an elder group that, that it provides some advice regarding child welfare cases. And sometimes things have to wait until those folks can meet, and just explaining all those processes and having both sides of the fence per se understand what each person does really can go a long way in just getting back to people and getting to know what people's schedules are. And one of the biggest things I tell workers all the time across the state of Minnesota is, if you're working with tribes out of the state, make sure you're paying attention to the time zones. I mean, it's as simple as that. And just think of the nature of child protection. Most tribal workers, in my opinion, at least, and in my experience, if you're having a day where you have a lot of court, the 9 to 4 o'clock is court. And so your best chance to reach someone is going to be early or later, or to leave messages with specific times that you're available to get back in touch with you, or to send times for a meeting to occur. But to just expect that folks just have all this time to be on the phone is something that I think a lot of people don't understand, that when you're the one tribal worker for an office and you're trying to manage things across the country, you simply just can't possibly answer all those calls. So you have to have things scheduled, or it's just how it is. So I just think that relationship building, though, is the piece that goes a long way. I want to, unless there's something else from our panel, I want to be able to turn it over to our parent who has joined us, Shayna, because she would like to share her experience, and we invited her here to share her experience in having an Indian child welfare case and just kind of what that was like for her. So I'm going to turn it over to you, Shayna, if you're available. And if you can go ahead and unmute your mic. Are you still there, Shayna? Or if I can. I see the number, I believe. I just wonder if I can unmute. Okay, I'll try again. Shayna, are you there? Oh, you can also.
She might have to go out and come back in if she's not able to
speak.
Talk. Yeah.
Okay. Yep. You might have to close out and then come back in if you're not able to speak, or to hit *6. We'll wait just a second and see if she's able to get on. We did have another comment while we're waiting here that someone, Tanya Cornelius, had said that she's also seen tribes transfer to tribal court so they can pursue customary adoption, which can't be done in state court, at least not in Wisconsin. I think, is that something that Mille Lacs and Red Lake both do?
Hi.
Yes.
Hello?
Oh, hello. Is this Shayna?
Yes, it is.
Hi, Shayna. Great. We are ready to turn it over to you. So if you'd like to just reintroduce yourself, I've told folks that you're here to share your story about your time having dealt with child welfare. And if you have any, at the end of your presentation, if you have any recommendations for tribal or county workers, we would love to hear your perspective. But otherwise, you just go right ahead and take it away.
All right. Bonjour, Watenurin Nakwe, Indigenous Cause, Makwa, Indudem, Mishkwagami, Luis Dagaigan, Indunjaba. My name is Shayna, and I am from Red Lake. See, I just want to express my gratitude for letting me come and share my experience with you today. I want to talk about the experience I had having a CHIP and ICWA case. It's going to be short because I'm actually at work, but I'll start. My experience was just like any other. To me, it was like a very traumatic. Can you hear me?
Yes,
Hello?
we can hear you.
Okay, sorry. It was like a very traumatic event. I was left helpless, hopeless, and severely depressed, and it literally felt like I lost a child again. Those same feelings came of losing my 12-month-old son. I had absolutely no control over anything. It was like a full-blown PTSD. My first appearance in court was somewhat of a relief because I heard I had an ICWA worker. Of course, not knowing what that was, I had questions. And as soon as I responded that Red Lake was intervening and stepping in, I just got teared up. Because having an open case, after hearing like all these bad things about the system is one thing, but when you hear you have the support of your tribe is definitely another. So I walked out the courtroom, feeling like I had a chance to fight. One thing that kept me going forward and fighting was when my baby girl looked at me. We were at a visit and she said, "Mom, my heart is broken." And tears were rolling down hers and my face. And I was able to obtain all necessary supports I needed thanks to the resources I was given through my ICWA workers. And I say ICWA workers because I didn't have just one case open, I had two of them. I don't know, it was different times, of course. So I fought and I got knocked down a few times, but I got right back up. Because truthfully, it just seemed like that's how the system wins. And I didn't have it in me to give in or give up because those are my children. I'd just like to say to those that are fighting the system, to just please never give up hope, and please reach out to the others that, like myself, and for sure to find out your resources and what's available to you. And I don't know, that's all I have. Thank you.
Thank you so much. And I apologize that you had to step away from work, but we really appreciate you sharing your story. And just thank you so much for joining us today. And I understand if you have to go. Um, I think that there's lots of folks thanking you for sharing. One of the reasons why we do this training is to, we did change things a little bit today to reflect our audience, but we really try to just provide information to our families and our relatives so that they can be as informed in when, if they are involved in child welfare and they go to court, that they understand what's happening, that they can ask questions, um, that they can bring things to the attention of, say their tribal worker, if something comes up in a meeting maybe where their tribal worker wasn't present, they can say, they were talking about, QEW and this, and it's always, I think, so much better for our families to be informed. And we just our team has really had a commitment to keep doing that. So I encourage you. I think it was shared earlier in the chat by Sadie or Nina on how to access our YouTube video. There is a channel. I think it's, correct me if I'm wrong, but I think it's the Metro Urban Indian Director Family Preservation YouTube. There's also a Facebook page for the Metro Urban Indian Directors in, or MUID. And we've posted things there before as well. And then on the Ainda Young, which is a nonprofit where Sadie is a part of, I know on their page they have some of her recordings as well. It looks like she's just posting it again. So please share that with families. We have other recordings. We have recordings on, what does a transfer of legal custody mean? If you have a relative that you're working with that is maybe going to take transfer of legal custody, what, basically breaks it down, like, what is that? What does this mean? What kinds of, things are expected of me? So yes, we just thank you all for allowing us to join. And I think that's it for us today. And thank you again to Mika Barrett and Ben Lundquist and Michaela Maxwell, and our committee, Sadie Hart and Nina, as well as Shana, for your presentation. Thank you so much, all of you. Miigwech. Is there any other questions before we end? Okay, then I think I'm going to turn it back to our host here. If there is anything else, let us know. But otherwise, we're happy to join you today. And thank you so much for having us.
Thank you, Laura, and your team. That was an excellent presentation or discussion. If there are no more questions or further comments, we will end the recording. Thank you so much for coming with us today.
Okay, great. Thanks. And great to see some folks' names that I recognize from work in the past. So nice to talk to everyone today.
Have a good day, everybody.
You too. Thank you.
Thank you. Have